what matter will
Take from that side. Yes. Any mention? No, ma'am, you'll take litigants last. Yes.
Yes, my lord, inclusion in the list as an application.
Application is
Same.
same.
Application.
Same.
My lord, may I permit one mention? To be mentioned, my lord, this matter heard by your lordship, my lord, day before yesterday, my lord.
Some correction.
My lord, with regards to the, my lord, the business of this appellant.
We want some correction.
Yes, my lord.
We mention yes.
My lord.
Hand over.
Correction, my lord.
Please.
Application.
Yes.
Oh, same as.
Yes, you want to mention something?
Lord, may I have your lordship's kind leave to mention item number 98 of your lordship's list? That is the matter what I mentioned yesterday. It has come in the list, but there's an endorsement now that the second judge's copy of the section 5 application is not there. However, it was moved earlier and there was no such noting. But it's possibly
If it's there,
in the
it's not
record.
there.
It's possibly misplaced in the records. Maybe do one more thing. Maybe prepare.
You prepare another copy and just come when we take up.
But I don't think I'll be here, but I don't think it will be taken up. Tuesday possession is going to be taken. Can it be there?
So Monday we take up applications first.
Monday, some precedents can be given.
Only Thursday on the prayer of the bar we have taken up. We are taking up appeals first.
I've seen
applications will be taken up on Monday.
Some precedents.
No precedents. Yes, ma'am. Yes.
Matter of Justice Honorable Justice Soman Sen, presided by the division.
What is the urgency in?
It's a real matter of I need to file an urgent application
without certified copy. You have a copy, serve a copy.
No, Lordship, I have the server copy and the requisitions.
Very leave is granted. Leave the din. Oh, this is for the origin. Leave the doctor. Yes, please handle. Leave is granted. Call. এটা শুরু করবেন ওটাতে অনেকগুলো ফুল একটা বার করেছি পরে নাম্বারটা উল্টে গেছে জাস্ট প্রোনাউন্স করে দিচ্ছি Accordingly, FA number 16 of 2012 is allowed on contest against the respondent numbers 4, 5 series and 6 and ex parte against the other respondents, thereby setting aside the impugned judgment and degree dated October 6, 2010, passed by such and such, entitled suit number such and such, and granting a degree in terms of prayer A, B, and C. We have quoted the prayers and the applications are disposed of accordingly. এটা পাঠিয়ে দেবেন করিনি ইচ্ছে করে অনেকগুলো ভুল আছে পাঠিয়ে দিন এটা
Lord, we are appearing for Union of India. Lord, we have filed 3 applications, 1 memo.
আচ্ছা এই অ্যাপ্লিকেশন গুলো আগে অ্যাপিয়ার করছো কেন পাঠার আজকে হিয়ারিং ম্যাটার আগে না
2 applications.
Oh, justice chain. Sorry. Yeah.
2 applications.
2 applications.
1 stay application, another condonation of delay, section 5 application.
So this is an appeal against what? What is justice chain's determination?
Yes, it is appeal against the order passed by the learned Chief Judge, City Civil Court.
This pertains to our determination.
Yes, at present.
No, justice chain's determination originally.
Yes.
No, the matter pertains to what?
The order was passed by the arbitrator.
Oh, this is against an award.
Yes.
This is section 37 or what?
Yes.
Section 34 must be. No, let us check up. Let us check up. If the award was passed,
yes,
you challenged under section 34 or what?
34.
That has been dismissed.
No. But
this is the 34.
No, City Civil Court passed an order
under section 34
against the award, directing us to pay an interest of so and so, which was not arbitrator allowed.
So this appeal is under what provision then?
This is not against section 34. In the section 34, there was a single order has been passed.
Under which provision?
By the Chief Judge we filed, there was an application filed by the respondent, and that
application was under what?
We filed in section 34 application, challenging the award before the Chief Judge.
No, in the section 34 an interim order has been passed.
Interim order, in that interim order we have challenged that.
That is not applicable under section 37. 37 is very specific. Unless it is section 9 or section 8 only those orders of the court are applicable before this under section 37. No appeal lies otherwise. Please take up the Arbitration and Conciliation Act. Section 37 is the only provision for appeal.
Section 34 appeal has not been dismissed. It is standing there.
Yes, we understand. No appeal lies against any interlocutory order passed there. Appeal is only maintainable under section 37 of the 96 Act. If it does not come within any of the provisions of section 37, then no appeal is a creature of statute. You are for the other side. Yes, what do you say?
The appeal have a time bar, 60 days time for date of passing. the-
Appeal lies. Payment of interest was directed on the awarded amount.
Section 34 application has been allowed, and
As Arbitration and Conciliation Act in 96. Please take up section 37.
that's right. That's all.
These are the only appellable orders. Yes, ma'am, satisfied now? See, if it's setting aside or refusing to set aside an arbitral award, that's the final order passed in the 34. That is appellable. Otherwise, it's only 8 and 9. These are the two orders passed by court which can be challenged. And of course, section 34 final order can be challenged. Section 16, 2, 3, 17, those can be challenged. So we'll hold that the appeal is not maintainable. Why should we hold you up unnecessarily?
You have to come by civil revision.
We won't advise you. We have much wiser head behind you. We'll hold it to not to be maintainable right now. So that you can go and pursue remedy. We'll give you liberty to take back the certified copy upon furnishing us a photocopy. The present application bearing can 1 of 2025 has been filed for condonation of delay in preferring.
For a moment, below, there was a last order of City Civil Court, which was implemented on 17th of this month. And give me some protection that
That's not
Not
allowed.
in a non-maintainable appeal. Can 1 of 2025 is an application for condonation of delay in preferring FMAT 43 of 2025. Pushed up. The said appeal itself has been preferred against an interlocutory order passed in a proceeding under section 34 of the Arbitration and Conciliation Act 1996. Pushed up. However, since appeal is a creature of statute and there is no provision for challenging an interlocutory order passed in connection with an application under section 34 of the said act, the present appeal itself is not maintainable. Hence, instead of prolonging the agony of the parties by keeping the appeal pending, what is the delay about?
121 days.
We hold that the appeal is not maintainable. Accordingly, can 1 of 2025 is dismissed. In view of the above observations, FMAT 43 of 2025 and can 2 of 2025 are also dismissed as not maintainable. Next para. Leave, however, is granted to the appellant to prefer an appropriate prefer a properly constituted challenge before the appropriate court/bench against the impugned order, as per law. Nothing in this order shall prevent such a challenge, if otherwise maintainable in law. If such a challenge is preferred, the court taking up the same shall decide the same independently in accordance with law without being influenced by the dismissal of the present appeal and connected applications. Next para. No order as to costs. Leave is granted to the appellant to take back the certified copy of the impugned order upon furnishing photocopy of the same for the records. ডিপার্টমেন্টে পাঠিয়ে দেবেন যাতে আজকে ওরা তুলে নিতে পারে।
I'm praying for short pass over your lordship as Mr. Dheeraj Trivedi is appearing on this matter.
What is the application for?
Respond to your lordship.
No,
Very
that
short.
determination matters we cannot give time because this is the only day we're taking up the matter.
Very short issue. Restoration application, section 34 was filed before the Barashat court. It was going on 2014. I'm talking about 2014. It was filed within time. It was going on. There was an order of stay passed. It's a pre-amendment stage, although pre-amendment stage, but even though
The amendment of 2015 or
2015. So even though not required, but an order of stay was passed and it was continuing till 2017. 2017 till 2018, I did not participate in the proceedings. My fault. I do not want to go into that.
proceeding under?
In the 34, I was not present.
All
But
right.
for whatever reason, that is subsequently. After that, the matter was transferred to the commercial court at Rajarhat without notice to me. And this is observed by the Rajarhat court when I filed the restoration application. Rajarhat court dismissed for default in 2019. And in 2023, when I came to know, I filed a restoration application. Rajarhat court, the learned court, recognized this fact, wrote it in the order that no notice was served, but even then restoration was
By the
dismissed.
impugned order, the section 5 has been rejected along with the order 9 rule 13.
Yes.
How is that appealable? Under
No,
which provision?
it's not- order 9 rule nothing. It's a section 5 application was rejected. It's
How is an appeal
section
maintainable?
34. Section 34 was the rejected.
No.
The
Section 34 was refused to be restored.
Yes, section 34 refused to be
That's
restored.
not the rejection of the section 34. Section 34 was rejected previously. If you challenge the section 34 rejection, then that would be appealable. This is not an appealable order. All these appeals are pending before Justice Chen.
This has been filed just now.
No appeal lies.
Section 30.
See section 37. We are sitting with section 37 because of these matters. See the language of section 37. We have just now seen it, but we are reading it for you. As far as your case is concerned, setting aside or refusing to set aside an arbitral award under section 34. This is neither. The refusal to set aside the arbitral award has happened when the section 34 was dismissed. This is a refusal to restore the same.
Yes.
Pursue
So
your
it is
appropriate challenge.
continuation of that proceedings only. Because section 5
Continuation of proceeding is, it's first of all not a continuation of the proceeding is no longer there. And if section 5 is rejected, that is non-est in any event. And secondly, continuation of proceeding is not a factor. A proceeding may continue, 34 may continue, whatever orders may be passed there are not appealable. Only the final order dismissing or allowing the section 34.
the dismissal order was
The present appeal has been preferred against the rejection of an application under section 5 of the Limitation Act filed in connection with a restoration application. First off, the restoration application was filed in
dismissal
respect of a
application was also
dismissal.
challenged. I'm sorry. The dismissal application is also challenged in this appeal. The dismissal
In one
of-
appeal, you cannot challenge both.
both the orders has been
You cannot challenge that. Then it's not in form. We'll give you liberty to challenge the main order, and this order also in an appropriate challenge. The restoration application was filed in connection with an application under section 34 of the Arbitration and Conciliation Act 1996. Full stop next para. However, section 37 within bracket 1 within bracket small c categorically provides that only an order setting aside or refusing to set aside an arbitral award under section 34 is applicable under the said provision. Full stop next para. Since the refusal to set aside the arbitral award happened with the dismissal of the section 34 application for default, the present rejection of the condonation of delay application in connection with the restoration application is not appealable under any of the provisions within the four corners of the 1996 Act. Full stop. Since section 5 of the said Act categorically provides that there cannot be any judicial interference except for as provided under the provisions of the said Act, we are of the opinion that the appeal is not maintainable, since the impugned order is not appealable. Full stop next para. Accordingly, FMAT within bracket FMA number 244 of 2025 along with can 1 of 2025 are dismissed as not maintainable. For sub next para, it is made clear that nothing in this order shall prevent the appellant from preferring an appropriate and properly constituted challenge against the impugned order and stroke or the principal order whereby the section 34 application was dismissed for default before the appropriate forum. Full stop. Leave is granted to the appellant, to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing photocopy of the same. Full stop. No rest to call.
Since Mr. Trivedi is here, with some indulgence because the execution application they are pressing, which is fixed on 21st.
In a non-maintainable application, cannot.
No,
This is
I'm
not
not
the
saying since the execution application they are pressing for it till on 21st, let them not press for it. In the meantime, let me take steps.
That's their choice. We cannot command them. Next.
I being a creature of instruction from Union of India of the capital. And
I live.
So take appropriate instructions, Mr. Trivedi. Otherwise,
what I was
Union of India will take some time to move. You can move your application for that.
but what was
The previous wrong appeal was by the Union of India. Therefore, we are confident that he is sufficiently protected.
my lord?
Thank you. Yes. Next. Call করেছেন এটা? Yes.
May it please your similar, I think.
Yes.
I should be concluding today. That last time I was saying the question that I'm enjoying the property without paying anything. That this factor brought to the notice of the court. Am I really enjoying? Because on their own application, I was restrained under Section 9 from collecting the occupation charge.
And you say receiver was also appointed.
Yes. And ultimately, they got a receiver appointed
Yes.
to collect from all occupants, and receiver doing so since the particular time. We have got a bunch of the orders. Paper book has it order, no?
Mr. Mithu, you need not place the Mr. Mithu, you need not place the orders. You just refer to the pages if it's in the paper book in your written notes.
Yes, that's give
Let's
us
do
a
that.
bunch of orders down. Give copy to them. Order going to ask us.
Just put it with your written notes. Just indicate in your written notes, Mr.
Yes,
Mithu.
that's right.
We want to conclude the hearing now.
Order going to this input that we have cited a judgment of our honorable court, Division Justice Mukherjee.
Yes.
Now, either 51 Calcutta, 853, 858. Two judgments have been cited that if the receiver appointed or the defendant abstained from enjoying the use of product, then no question of mean profit.
Right.
Mean profit definition is amount, how much amount I could have earned.
Absolutely.
I give the reference of two judgments.
Please give the references for them and we'll take the judgments.
This is reported in AI 24 Calcutta 1016, but that is not available. ILR 51 Calcutta 853 at 858. কোনটা এনেছো? ILR এনেছো না AIR এনেছো? কোনটা এনেছো? আমার brief আছে। AIR এনেছো? Oh, sorry. And AIR is 24 Calcutta 1016. And then latest division and judgment of AIR 1986 Calcutta 393. Both judgments say the same thing, but Lordship may like the language of Justice Mukherjee in that ILR 51.
You can read out, Mr. Mitra. No difference.
It may like this. এনেছো তো দেবার সময় এসে গেছে না? Yeah, 1956, sorry, 85 Calcutta, I give the paragraph numbers. Numbers are 6, paragraph 6 onwards, and 8. And 8, 6 to 8.
And please ask your learned junior to just put it in his written notes of our book.
Notes.
The reference.
Notes. And this either is Calcutta in a more precise language, why it is not so.
All right.
Yes. Therefore, not these prejudicial facts which have been relied mostly by them, I mean, enjoying the property without it.
Yes.
From 2012, there's the injunction order. So, that is. Now, next comes the question of learned. Good. Should I hand over the copy?
Yes, yes, you can. Or you can annex to the written notes.
Written notes.
Yes,
All
yes,
right.
Mr.
Thank you. Next point is that when the division bench relied upon, the division bench said that one cannot enjoy the property without paying the occupation charges under 64, 65 of Contract Act. Very good. Therefore, I can enjoy the property upon payment of occupation charges. How does it become a ground for eviction? Not only one judgment I will cite on this point. 1985, Volume 1, SCC. Now, which is at page 316 of the compilation.
We'll find that from. 1985 1 SCC.
1985, 1 SCC.
Page 313 of the compilation. We have it.
Page
313.
Compilation page
313.
313.
313, Mr. Mitra. (1985) 1 SCC 575.
What copy the class? Here, Miller, the court has said, following the Privy Council, that I shall only that portion I shall place. Paragraph 3, continuation at page 318. Last paragraph, where Supreme Court, the Privy Council is considered convicted in this. We do not have.
Yes, we do not.
We
do not have the slightest doubt.
We do not have the slightest doubt that net profit realized by the company as a result of all various business activities can never be the measure of compensation to be awarded on Section 65 of the Contract Act. It is not as if Section 65 of the Contract Act works in one direction only. If one party to the contract is asked to disgorge the advantage received by him under a void contract, so the other party may ask him to restore the advantage received by him. Restoration of advantage and payment of compensation are necessary to be mutual. So they have to refund the amount they have paid. This is the form this Privy Council has been noticed, Section 65. Section 65, each of the parties is bound to restore any advantage which the restoring party received. Now, this has been followed by the Supreme Court in this judgment. Medically similar. As a result of the contract being void, state would at the most recover from the contractor the value of the rough stone excavated from the quarry. It was a mining lease.
The usufructs of that.
The mining lease.
Yes.
But then it would have to make good to the company the expenditure incurred by the company in quarrying operations and extraction of rough stone. Is for the reason that the court, instead of involving the parties in impossible and speculative calculation, adopted the basis of royalty as the measure of compensation. Royalty, as is well known, is in the case of lease of a mine, the payment reserved by the grantor proportionate to the amount of demised mineral worked within a certain period. In a case like this, present where the grantor of the state and the lease is for excavation of stone, measured of the compensation payable to the grantee should be the reasonable royalty which the state would have otherwise received from the grantee. Had the grantee not paid a fine under the contract on the ground that the contract was void, in our opinion, he would be liable to a reasonable royalty for the excavated stone. In addition, he would also be liable to pay compensation for the exclusive right granted to him. That was how the High Court proceeded with the matter, and we see nothing wrong with the approach of the High Court. Similarly, this is what an agreed range is not a criteria. Has to be assessment. Has
Here,
to be-
unlike this case, their mining, the quarrying was the source of income.
Yes.
It was exploited. Here, you could not earn anything because the income was derived from the rent, which is stopped.
Right.
You cannot take.
And not the court can say if for earning this
Yes.
income, profit, you have to incur expenditure. But in our case, it was running as a warehouse. So running this income, we have to do some warehousing jobs, namely loading, unloading, etc. Anyway, that is not the point. Point is mainly that lease rent is not a criteria. You have to make a safe assessment. Then not kindly read a section 65. Nothing. Contract Act section 65.
Contract Act. Okay.
It clearly provides that option is to be given to the defaulting party to either pay or to make it. 65 or this one. Contract Ashwini. Okay, he just did what dot he just. The weather agreement is what?
Mr. Mithra, you can take our copy and we have.
That is simple. Am I not right?
Yes.
Section provides, sorry, I would like to document.
Yes.
When an agreement is discovered to be void or when the contract becomes void, any party who has received any advantage answer is bound to restore it or to make compensation. Or to make compensation.
Yes.
For the person from whom it is or to make compensation. That is not as well judgment 1985 Supreme Court also deals with that. আমার কপিটা হিসেবে সুপ্রিম কোর্ট দাও না 85 সুপ্রিম কোর্ট আমার দাও এই হিসাবে আমি হ্যান্ডেল করি আমার তো দাও clearly বলেছে ওটা ought to pay compensation. Okay. Option is mine. Judgment that judgment to that specific them to that effect. আসেনি আমার আর কোনো বই আসেনি দেখো one moment.
So therefore, Mr. Mithra, your case is that compensation could have been directed at best.
Yes.
And you would have paid if it was fair.
If
but
I don't
not
pay,
eviction,
then I
yes.
take
If direct outright eviction is not the
that is the point.
Yes, yes, you're clear on
that kind of inquiry will be outside the agreement. Agreement has become void only.
That
in this case, court has not held it become void. Agreement has become void. Then arbiters first hold. Agreement has become void or is void. Then only. And receipt. Because you remember the language of the award. If the party applies, if the party takes steps to rescind the agreement. So 60 or 65 is not the ground for this award for eviction. But I have to give the option.
Yes.
Now, the next thing, I have not placed the judgment of the trial court, which is has not been appealed. I should. I have not placed it because, with due respect, and judgment of trial court is at volume 5, 1032. Volume 5, 1032. That I briefly similar. I have not, because the trial court has not at all decided. Argument was made that this agreement is a lease. He has noted the argument, but has not said anything on that.
We can come to page 1045.
Yes,
One
and
to
the
1045, the decision portion starts.
Just what you last year, what was argued, relevant part.
Yes, yes, need not read the entire thing.
I'm omitting the relevant part.
Mostly statutes are quoted.
Company went liquidation, there's facts. This will kindly page 1036, ground 11, 8.
Yes.
8. If column prior to the expiry of the said period of license revoked and terminated the said lease by letter dated effective and by your abundant caution, it was issued. Issued the letter, etc. Under second 106. Then it is true, it in the case of Calon, in spite of issuing notice, they are not vacated. Expired. And the period of lease also, period of license also expired. This is a ground case of Calon based on agreement. Both are based on the agreement. Then Mr. PC having next page 1037, Roman 12.
Mr. Mitra, let us skip over the grounds.
Yes.
We can come to 1045 directly.
I've seen the grounds
This
are
need not.
no
Commercial court having jurisdiction, there was no dispute on that.
No
Dispute on that. So that was framed as an issue. We can need not look into that. Otherwise, it's commercial transaction and the specified value itself.
Then may I come to that? I have also
Yes, mostly quoted the arguments.
Judgment without reasons, it should be set aside by the appeal king.
What is this?
Issue number 1.
Again, he goes on discussing the arguments. Even after that.
Paragraph 2, 1046. Although this point has not been raised during argument, either by the Star Trek or Epsilon, this court thinks fit to adjudicate the matter as per the direction of the Honorable High Court in FM1 in that division. This is totally, that's the approach of the trial. Besides, as per the order of division bench in the other arbitration proceedings.
Issue number A is not relevant because that is commercial court issue.
No, come on.
So you can come to issue number B, 1053.
In Commercial Courts Act referred to, I do not know why. Commercial Courts Act provides.
Maybe that objection was taken. That's the first issue, whether the commercial court has jurisdiction.
It must come to 1053.
Yes, Mr. Mitra, we are there.
Issue number B. Before dealing with the grounds of preferring the present application against the award, etc., it is better to deal with the some of the important objections of the target. Number one, it argued Star Trek that there exists no valid or legally enforceable agreement between the parties. Accordingly, it should be set aside. This is should have said not admissible evidence. Before dealing with each and every query, it has to be taken in consideration the agreement dated census and another arbitration proceedings was held between the parties. And against the award so passed by the London arbitrator, Sri Povi Rai Chaudhary, in a said agreement, application has been preferred for setting aside the award at the London arbitrator. And subsequently, against such order, an appeal has been prepared, which has been disposed of Honorable High Court, number again by order number 25, etc. In another proceeding, connection, etc. General conference. As a result, Lord members are appointed in these proceedings. Very good. Appealed by the High Court, Apex Court. That's a justice division judgment appealed by the High Court. Some points which have been raised by the Star Trek have already been discussed and dealt with by the Honorable High Court at Calcutta, affirmed by the Honorable Supreme Court, etc. Nothing. None of the points argued is discussed or decided either way. Unregistered, except nothing there. Then the order was set aside. Long that way. Then kindly please come to 106 argument summarized. Instead of going page by 1060.
Yes.
Roman 16.
Right.
Very specifically, argument advanced by Mr. Kundu on behalf of Star Trek is summarized. Honorable Division Bench of High Court at Calcutta partially set aside the award. Learned Sri Povi Rai Chaudhary, so far as concerned, entitlement of Star Trek to remain in possession. Other thing of learned arbitrator has not been interfered with by the Honorable Division Bench. Agreement dated is partially set aside and not fully set aside. This is I do not get a sense of this argument, although on my side. Agreement was not set aside. Anyway, that's a point. In this conclusion, Mr. Kundu referred to so many judgments. In the agreement advice, judgment quoted in a contract in the agreement in the department order. Argument noted. They simply follow the division bench of the other matter. Can see paragraph 8, 1064. Simply follow the division bench order in the other arbitration. Paragraph 8. Yes. Observations of the Honorable High Court so far as the fate of the agreement dated 26/12 is concerned is conclusive. One, and neither the learned arbitrator nor this court has any authority to make a departure from the solemn order as passed by Honorable High Court at Calcutta. And since such order relates to agreement dated 2011 by and between the same parties, the issue is referred to Star Trek and has no application in this case. But what the division bench have not said, nothing has said, that the agreement, December agreement, it is valid or invalid. Arbiter held is null and void. And that aspect, division bench said, is I are not we are not interfering with. But this is not what is assuming that judgment is enforceable here. How does it go against me? On what point? On what point? Only thing that nobody can occupy a property, enjoy a property without paying occupation charges. Very good. That's the only thing the division bench has said. That was not a ground for the only thing only COVID. On the other hand, division has not interfered with the arbitrator's finding that agreement was fraudulent misrepresentation and null and void. Judge Miller has gone on a wrong approach. See paragraph 9. It is another contribution start track that the counterclaim in prepared by F. Callan was not pressed by them, and such counterclaim was abandoned by F. Callan. Therefore, present reference is barred by res judicata, not res judicata, it is barred by law. 9. This point needs no further discussion, as the award having been set aside shall have no legal existence. A counterclaim is made before justice arbitrary, actually, which was not pressed. That counterclaim is actually award being set aside. What? Nothing to do with that. Nothing to do with that. It is barred will be under order 23 of the Supreme Court. But he has not answered this question. The point was argued. That when I said, and asked me whether this was argued or not, I didn't tell you, Lordship. Point was argued before the single bench, before trial court, but not really adverted, not really decided. He gone a wrong thing. Not res judicata, cannot be no question. Matter application not pressed for cannot be res judicata. No risk adjudicated upon. That is because order 23.
Yes.
Then similar to why this paragraph 11, where our High Court held arbitration agreement is valid. That is not in dispute. It's not in dispute. Similar, this is quoted. Where court held that arbitration at the time of reference, the arbitration agreement is valid. When the second reference was sought for by the F. Callan, the court held this arbitration agreement is valid and that is not disputed by the parties. I'm correct. Arbitration agreement is valid. Then see the ground 12, start track has gone to Honorable Supreme Court of India by special petition, but the Honorable Court dismissed the special petition. As result, point is raised that was special petition was filed not against order of review, filed against the order of division bench setting aside the award partially. That was dismissed by the Supreme Court. And but that judgment, it is not against the review petition, which has no appeal whatsoever. What review petition does, that is something. Fresh reversal did not occur eviction. And the objection, Star Trek, in view of the judgment of Supreme Court, in such and such case, eviction or tenancy matter cannot be arbitrable dispute. As in the judgment on Supreme Court, I do not. Buzalin. But that is, I don't know how it is argued also. I doubt that Mr. Kundul argued, I doubt. Because Buzalin says not what you know, I tell you, I don't at all support this argument, if made, and then not even. Because if a tenancy is governed by the Tenancy Act, then only it will not be arbitrable dispute because the court has given exclusive jurisdiction. Not on the Transfer Property Act like this. This argument, I don't think it is at all to be raised, and if I doubt Mr. Kundu has raised this, but I am not repeating this. This is ineffective. Please come to 17, paragraph 17, 1067. On behalf of Star Trek, Council has drawn my attention to the fact the lease agreement dated such was not duly stamped and cannot be relied upon without impounding. It has not passed any order for this. Then Mr. Chaudhary, earlier advocate, says the same document has been relied upon by Star Trek not only before the erstwhile arbitrator, that is Pravid actually, also has not given any objection when the document has been properly marked as an exhibit. It's totally wrong. This agreement, and now I tell you, Lordship, has not been marked as an exhibit before Justice Toppensen. That's a point we're taking. Not marked as an exhibit. Please see me out. Volume 3, page 615. It was disclosed but not exhibited. Still holding. Volume 6. Volume 3, volume 615. Yes. Six one five. It was produced. Can you see this, Milord? Moreover, 615 middle. Moreover, the argument of Mr. Nath to the effect that our agreement cannot be looked into because it was not duly stamped and in terms section 20 of the Stamp Act cannot be sustained because of section 36 of Stamp Act, which lays down that when an instrument has already been admitted in evidence, same cannot be called in question on the ground it was not duly stamped. This agreement was always acted upon and it was relied upon by the respondent not only in the earlier arbitration proceedings, but before Mr. Pravid actually, but it was also relied upon before the first appeal referred to above, and therefore now they cannot contend, document cannot be looked into because it was not stamped. Very good. Now, this is page 614 down. Section 36 relied upon. Section 36 is another arbitration proceeding, assuming it was looked into. It was, but in this Section 36, waiver allows, if it's the same proceedings. Language is very clear. In this case, in the arbitration before Justice Toppensen, the point was taken from initially by Section 16 application. Point was taken initially. And this document was not exhibited. That I'll show to you also. Why do we say? This is the matter. But that is the answer of the trial court. Stamp Act, because 36, Mr. Contended. It has been exhibited. Well, Mr. Justice Toppensen has not said it has been exhibited in these proceedings. It has gone wrong. Has not said. Party acted upon the agreement. Very good. That is outside court. Party acting upon the agreement. No Inconsistency, yes. চলে গেল কোথায় বলতে? ওই judgment এর বাক্য there is a minutes of the proceeding and show you এটা কি? Huh? Yes. That may I draw my kind attention to the affidavit of evidence affirmed by them in the proceeding before Justice Tomlinson, and similar to what document there is that as exhibit. Evidence. Yes, but see this paragraph. They have made an annexure of the list of documents. That was actually the yes, or not? How to show? What is being output exhibit A, B, what the thing says in the affidavit evidence, exhibits are given A, B, C, D, E, F. None of them. Agreement is not an exhibit. He said all the exhibits up to J, K, K. This agreement is not mentioned as an exhibit. This is affidavit evidence.
Yes. Only two other agreements were exhibited as exhibit F,
F.
which is not this agreement.
Exhibit
F at para 13, page 9 of this.
Exhibit F is not.
Those are two other agreements. Service agreement and some other.
Agreement between them and staff track.
And service agreement.
This is an agreement between me and my staff
Different.
track.
So none of the other exhibits are agreements.
Agreement is not.
We have checked up.
So that is one point. In addition to all legal argument, you can have document which is not exhibited. On the basis of that document, no award can be made. That is the point you then argued. And here that point was argued before the trial court.
So on this, you have 3 points. One is it was not exhibited, could not be relied on. Secondly, even if that document was relied on by you in a previous case, section 36 bar of the Stamp Act and section 17 read with 47 of the Registration Act operate in respect of the same suit. This is a different proceeding.
Same proceedings.
Proceeding.
Same
And,
proceedings.
and thirdly, also that you could not have waived a bar of law. That you argued on the last.
I've argued.
Yes.
But this therefore, I have not placed so much of this trial court argument because trial court
Need
has
not. Repetition is
better approach.
repetition, too many repetitions, yes, in the judgment.
All the reliance on the division bench judgment in another arbitration proceedings award for setting aside that award or that is how we second.
No, if a previous arbitration award is there in respect of the same agreement between the same parties, why shouldn't those findings operate as res judicata?
Yes. Right.
Could have operated as res judicata. But even if that be so, you have argued that the division bench, it merged the award, previous award merged with the division bench. And what was set aside was only that that occupation you cannot enjoy without occupation charge.
That portion.
And agreement was held to be valid, you were saying? And division bench did not interfere with the null and void part. Yes.
Not. But in the second arbitration proceedings, you proceed on the basis agreement is valid. Has not been, is not null and void.
No, but the division bench, there is a contradictory finding. Apparently, division bench was quoted in italics previously in this judgment, which says agreement held is valid.
Agreement
held is valid. That was some pages back when you were referring to that.
Subsequent, no, the lease was obtained later on. That was agreement became
page 1066
1066.
That's a continuation of 1065,
Yes, please.
where in the review application,
1066.
that's
Yes.
the italics is the review
Validity of the
application.
arbitration agreement not in dispute. That portion.
Yes.
Yes. Validity of arbitration agreement not in dispute. Arbitration agreement is independent of the lease agreement. That is the Supreme Court has now laid down.
Very.
Validity of the arbitration agreement not in dispute.
Yes.
So arbiter has the jurisdiction to interpret the agreement and decide whether it is a lease or license. That is the one. Now, may I move on to the other point? Let's see what the learned said. We have brought a judgment that arbitration
Need not multiply judgments unnecessarily if you feel so, because we won't be going through the judgments. The more judgments you cite, Mr. More will be cursory and will give an impression that you have read the judgment, but we won't.
All of company is repulsive. So what I am concerned, I am not going into. I have to read my own book, own book. Next matter, quantity losses. All these about stamp act, but they all this judgment, etc. Argument forgot about registration point. That is very, very fatal. Now let's see that here on the registration point.
Did you argue registration point?
Registration.
Did you argue registration point in the court below?
Yes, yes.
You had argued registration point also.
Not yet. You know, order 6. Yes, yes. Lots of order 16 or about going on. Order 16, yes, very, very thoroughly argued. Maybe
in the section 16 application you had.
Section 16 is down. 607 down.
You can just give us the page number, Mr. Mitra, then we'll just take a note here.
Page
number of the paper book where in the application.
Order 16 order.
Section 16, yes.
Sorry, taken order that starts at page 607.
No, not that. Where you have taken the point of registration. Only that portion. The stamp you have already obviously taken away. Just give us the volume and the page number.
611. Both stamp and registration.
And that is at volume?
Volume 3, na? Volume got to it.
3. Yes, very.
611, Section 17 Registration Act.
Yes, yes.
And stamp act article, both have been taken.
Thank you. Thank you. Yeah.
Because this is one of argued very clear.
Yes.
Now the registration thing, they have now we have been shifted to stamp act rule.
Only stamp.
I maintain my stand. Stamp act is applicable. They have looked. But registration is another thing. But registration, stamp act, they say, is for collection of revenue. People say. But the registration act is a matter of public policy. When a document registered, the document comes in the public domain. Certified copy can obtain, etc. There's the excellent judgment of Madras High Court, old judgment, AIA 1917 Madras 718, paragraph 5 to 9. The registration is a public policy. Registration Act. And Supreme Court judgment, I rely on another judgment, 2008, 8 SCC 564. On the registration pointed. Again, it's a Madras data 5, paragraph 5 to 9. Okay. Yeah, that's funny. In the meantime,
yes,
searching for it.
Yes,
2008, volume 8, SCC 564, paragraph 36, 44, and 45. What is the effect of non-registration? It was based on the suit was based on a
Can you
memorandum
please
of
repeat the
fee.
paragraph numbers, Mr. Mitra? Can you please repeat
Paragraph
the?
is- Paragraph number is 34,
Yes.
then 44 to 45.
Right.
If I may come straight to this paragraph, it was lease agreement.
Yes.
Other paragraphs
Need not.
give you the idea of that. Document held to be leased. Then minute, kindly come to paragraph 34. At page 577.
Yes.
From the principle laid down by various decisions, Vetlamar Bishan has been quoted before that, of this court and the High Court, as referred to in here and above. A document required to be registered, if unregistered, is not admissible into evidence under Section 49 of the Asian Act. Thus, unregistered document cannot, however, be used as an evidence of collateral purpose, can, however, be used for purpose as provided in provision. A collateral transaction must be independent of or divisible from the transaction to effect which the law requires registration, independent. A collateral transaction must be a transaction not itself required to be effected by a registered.
Mr. Mitra, this cannot be a collateral transaction for the
Cannot,
purpose of
nobody is
this.
saying that.
Obviously,
It's the
because this is the document they rely on.
same, clearly. And what is the effect of that? Paragraph 44, 45.
Right.
At page 579. In view of our discussions made here and above, we are therefore of the view a clause 9 of the agreement, which requires respondent to use the suit premises only for this particular named officer, cannot be looked into, even for collateral purpose, and the decision of this court in such a case would not be of any help. Secondly, you are of the view that although the suit premises were leased out exclusively for the named officer of the respondent, fact that respondent sought to use the for some other officers.
But
would
these are not
constitute
relevant for the present
tender
case.
use. That's it.
These are not relevant for the present case. 34 is your paragraph.
And this document, difficulty on even that unregistration cannot be cured. Stamp Act, you can pay the Stamp Act impoundment, cured it. But registration cannot be cured. And both points were taken here clearly. The key. We can see the Madras High Court judgment. This is of old heritage. Justice Sadashiva had and Justice Philip. Paragraph number is 59. 529. Please come, Miller. Yes.
If you just give the citation for Mr.
Paragraph.
Chaudhary, this is
Paragraph 529.
yes, yes, got it.
It is AIR. That's 17 Madras 718.
Right.
When documents are made merely inadmissible, paragraph 5, in
Paragraph
evidence by statutory law for the non-payment of proper stamp duty thereon, it may be a question whether public policy requires the admission in the pleadings of their contents to be rejected by the court, especially as the Stamp Act itself enacts that when a document is once admitted in evidence, though not properly stamped, the admission cannot be called in question afterwards. Observing that, remember, though not properly stamped, the admission cannot be called in question afterwards. In the suit, same thing. See the last paragraph, 5, except section 35, a criminal court might ignore section 33. Clause 2A of the Stamp Act, except most unstamped and insufficiently stamped document could also be made admissible in evidence on the payment of proper duty and penalty. The courts again are not usually inclined to treat an enactment relating to revenue as involving such large and grave principles of public policy as govern enactments relating to such large and grave principles of public policy as govern. But where a document is
No, Mr. Mitra, you missed the crucial line. The courts again are not usually inclined to treat enactments relating to revenue as involving such large and grave principles of public policy as govern enactments relating to registration and attestation. So, therefore, registration and attestation statutes are large and grave.
Public place, public policy.
Yes.
And now we are saying that, but where a document is not merely made inadmissible in evidence wholly or certain purpose, as to section 49 clause C, Registration Act, but the legislature further enacts a document not registered shall not affect in respect of any immutable property, generally or particular restriction, can be legally effected only by document complying with the prescribed conditions as to the attestation. Section referred to Transfer Property Act 107. Such provisions must be deemed to have been enacted on the high grounds of public policy. And a court should not, in my opinion, be astute in creating loopholes for evading plain intention of the legislature. I do not think it would serve any useful purpose to deal in detail with all the decisions quoted by Mr. Ayar. Most of them would be distinguished. A few others could be distinguished on the ground a defendant, without referring to the inadmissible and ineffectual document, admitted the plaintiff's right be given a decree for a period of the relief claimed by him.
Mr. With the subject to correction, the relevant portion has been read by you. Here, the court proceeds on the premise that inadmissibility by way of insufficient stamp can be cured. Not grave or large public policy, but registration one step ahead, because it's not a mere question of admissibility by the court, but no transfer takes effect by virtue of that document. Therefore, it goes to the root.
Document becomes
the document. I mean, admissibility is not the factor. The document itself does not pass any title.
Right.
So, therefore, that is the premise on which. Very
good. This aspect, Madras could said earlier, so simply saying registration make a document inadmissible, so is not enough.
This
In my
aspect
humble
was not
would also add,
right.
It is to be against public policy.
Yes.
And that will vitiate the award.
Right.
But there were two judgments I am citing for this proposition. Then, my lord, may I just now come to the concluding part of my argument.
We are searching for the concluding part, actually.
What are the first two? Now,
public policy you might be harping also for the purpose of section 34 language. That's why you are repeating for public.
Public policy, wild horse. Wild horse.
Yes.
So in the context, public policy, what is that?
Right.
Registration is based on public policy. Because one thing I think document registered, document becomes a public domain. I can open a certificate copy of a document, and so they're lost to know the law is when the document registered, deemed knowledge.
Yes.
Deemed knowledge.
Notice under section 2
right.
Transfer property.
Yes. Now I'll now come to relieve your lordship of the boredom. I come to it. Before I come to the next point,
yes,
the document was not agreement not exhibited. Will be further corroborated from the minutes of the meeting of the arbitration. Page 3 of the minutes. The questions are given. Similar, the affidavit of evidence is tendered and taken on record. Page 3. Would they copy it? Would that a copy?
Yes. Tendered and taken on.
Last paragraph, page 3, affidavit evidence is tendered and taken on record. It's Anirban Kaur says all documents which have been appended to the affidavit of evidence which have been tendered today have been served upon the other side. Documents are marked as exhibits.
And you have produced the affidavit of evidence itself, which does not mark the document.
And the affidavit evidence is tendered, and that is marked as exhibit.
This is the only thing which is. Yes, get your point.
Now, may I come to the meeting? That I have made many arguments.
And Mr. Mitra, before parting with registration point, you say that registration point, and you showed us also arbitral award does not deal with the non-registration part at all.
No.
But if you come to page 1080,
Yes.
para 39 of the judgment of the learned trial judge, which we are placing.
Yes.
This is page 1080.
I'm blessed. 1080. Yes.
Here, para 39,
39.
39,
Yes.
second sentence,
Unfortunate stamp, unfortunate stamp attempts have been made.
the next sentence, the arguments.
Argument is raised on the issue of insufficient stamp duty, non-registration of the impugned agreement, have dealt with by the learned arbitrator in accordance with
So have been dealt with by the learned arbitrator, he holds,
In
which
other-
according to you is perverse because it was not. Non-registration was not dealt with by the arbitration.
not in accordance law. That is simple saying without reasons. It simply said arbiter dealt with
No, not even not in accordance with law. It was not considered at all.
Yes.
That is your point.
10 minute law. Actually, in my mind, no ground is shown to establish a start track to come to the conclusion of what is opposed to public policy. These are all conclusions, all conclusions, but no reason in support of this conclusion. Arbiter has done it according to law. No reason given, just one bold statement. Anyway, but now matters come up with appeal. The other side have raised had the point in that appeal court order, appeal court on section 37 is more constrained than the trial court. That is not correct. They have relied upon a judgment which I rely upon myself.
No, it has to be guided by the parameters. Section 37 against section 34 has to be guided by the parameters of section 34.
Same. That's what
34,
I'm
yes.
pointing out.
Yes.
Same. The judgment which they rely upon in the notes, I rely upon the very same judgment. 2024, volume 7 SCC, 218, paragraph 26, they relied upon in the judgment. That's what happened, they have relied upon this judgment, paragraph 26 in truncated form, like clause 4. The first one sentence they relied upon. So copy the one like that, copy never like that. Copy chai can what be reported judgment kind of copy chai. Paragraph 26 that kindly come.
Yes.
26. The jurisdiction of the appellate court dealing with an appeal under section 37 against the judgment in a petition under section 34 is more constrained than the jurisdiction of the court dealing with a petition under section 34. Then it is line then it is duty of the appellate court to consider whether section 34 court has remained confined to the grounds of the challenge that are available in a petition under section 34. Ultimate function of the appellate court under section 37 is to decide whether jurisdiction under section 34 has been exercised rightly or wrongly. While doing so, appellate court can exercise the same power and jurisdiction that section 34 court possesses with the same constraint. Same thing.
Apparently, Mr. Mitra, parameters should be same. Because the parameters cannot be same for a section 37 against a section 17 and a section 37 against a section 34.
That will be
Obviously, it will be colored by the parent provision under which the
it will
impugnment.
clash.
But a bit stricter, maybe section 37 in the sense that Mr. Mitra, suppose another view is possible on the same set of those general restrictions are there in addition.
In orders with discretionary nature.
Discretionary nature, we cannot interpret. Right.
Otherwise, we all know.
Otherwise, 34.
That appeal is a continuation of the original proceedings.
Yes.
The appeal court sees everything. Powers are not constant, are limited. Now, the next 2 points, I think I'll be finished before 12.
Thank you.
Is that assignable document, therefore not a license. Remember the cost title the parties.
Yes, yes.
That
That's
now
right.
I rely on 2011, Volume 5, Supreme Court Cases, 270, paragraph 18.
Instead of handing over all the judgments, you have handed over some. You can just annex to the written notes.
That is better. It is.
And since this big bundle is here,
Page 150, but
wait,
19.
if those are already in the compilation, need not submit the judgments, further copies of the judgment. If not in the compilation, and if you have not additionally supplied, then only hand.
Sir, may I take one step further, my lord? Please discard that voluminous threatening document.
Just
Whatever
make it
judgment is right,
streamlined. Yes.
given
And Mr. Mitra, you personally settle the whatever is given, because
Yes.
please ensure that
whatever done.
unnecessary repetition of judgments
No,
is
no.
absolutely. I mean,
No, yes, sir.
you know, Mr. Mitra, with your experience, we don't look into the second, third judgments if it's a repetition.
But
We're
have
supposed to look
cited-
into the judgments, we don't.
Reminds me, we have cited 5 judgments for the proposition that the interpretation agreement by an arbitrator is susceptible to judicial review. It is not sacrosanct. And it has been set as a Supreme Court, at least in 5 recent judgments, where arbitrators have not considered all the clauses. Violation of 28.3
23 is there, yes.
and section 31, when reason, I have taken this down, violation 28.3, violation section 31.3, because then it's not a reason order.
Yes, yes.
Then he has taken a wrong approach. He has not considered at all the criteria for deciding legal license, as laid down by Supreme Court, which judgment was cited before him.
And
These are-
section 23 violation and 31 violation in turn also attract section 34, 1A, 4, and other provisions also, and also patent illegality, as well as fundamental policy of Indian law, certain judgments are there. So these are all discussed. I mean,
I give the brief bullet point that these are the 5 points on which I was saying.
yes, yes. Probably in SGS SOMA, it has been discussed everything.
And assignable is that I'm giving reference to judgment, paragraph 18, read out. Just simply read out, don't bother about it.
Yes, yes.
But this
Please,
will give
absolutely.
you spondylosis. A license under the inter alia A is not assignable. B does not entitle the licensee to sue the stranger on his own day. C, it is revocable. And D, it is determined when the grantor makes a subsequent assignment. Right and obligation of the license is not responsible.
It's a mirror image of the definition of lease.
That's why we not
Just the reverse.
remember I cite a Supreme Court judgment which when the document contains giving a notice, 3 months notice.
Yes.
Supreme Court itself says license is revocable at will. When it requires 3 months notice, it cannot be licensed.
Just a mirror image of
Judgment.
definition of
Yes.
lease. Whatever a lease is not, a license is.
And we not 1969 Supreme Court cited only one repetition, 1971, 1 SCC, 276, paragraph 8 to 11. On the ground, same thing, I don't also say I know all this. A transfer of possession,
Yes.
one criteria, but exclusive possession.
Exclusive, yes.
That we have seen, these are the 2 criteria.
Probably it has been crystallized now, transfer of exclusive possession and control. That is the yardstick.
Here, humbly point out, Lordship,
Yes.
arbitrator has not held that there has been no transfer of exclusive possession or there has been transfer of possession at all.
And bolstered by your placement of those clauses, 3 months notice, 6 years, and the other clauses also which you placed, which you have marked also.
But it has, in the absence of any finding of the arbitrator, that yes, it is no transfer of possession, no transfer of interest, no finding. So how can this order be of any substance, any sustainable? Then, my lord, 2022, volume 2, SCC 275, paragraph 26, again a repetition. This is repetition, non-consideration of clauses of the contract. Is it remarked?
1 or 2 judgments would suffice on that. That in the statute itself.
Allow 2 judgments on the same point.
Because if you find that there is some difference in shade, some other subtle nuance has been brought in. Otherwise, don't repeat judgment. Give the latest, we'll most of the latest judgments nowadays, Mr. Mitra, quote all the previous judgments.
All the.
The law clerks have to have some duties, have something to do.
Sometimes get inspired by Supreme Court judgments, which decides all the judgments, about 10, 15 judgments.
We are inspired only by the precedentiary value of the Supreme Court judgments. Because neither of us has a law clerk.
Ultimate conclusion.
We are only impressed by the precedentiary value. We are bound. 141 is there.
Is, whatever the way look at it, this agreement is an agreement of lease.
Yes.
And there's no order, 16 order should be set aside. Second, if therefore arbiter proceeded for the prima facie finding, etc.
Yes.
Interim award, he had no jurisdiction to proceed further.
Right.
Order. Number two, I've said, even if my first argument goes, the arbitration, the final interim award, which is final award, the only ground I could decipher is expiry of the license and language. That for that he refers to agreement clause 1, say that clause 6. Therefore, my lord, if he denied award is based on a agreement or document which is not admissible in evidence, unregistered, which does not affect any transaction being unregistered. Therefore, that award that also should be right. Other award mirrors long discussion on any point, but the similar what is the ground for eviction? Yes, we have made many arguments, appropriate, reprobate. Reject that. Rejection of the defendant's argument is one thing. Then the court has to say, I will say, on this ground, I pass a decree in favor of the plaintiff. I may say suit is not maintainable. Very good. Reject that. But then court has to say, I pass a decree of eviction on this ground. That is personal use or whatever ground may be, or tenancy at will, khatam, by notice only. But that is only ground I find. But those are humble submissions.
Thank you.
Now, learned friends.
I'll request you to file a short, as brief as possible, bullet points, written notes of arguments, and.
Learned friend, now my pleasure to hear him.
No, it's his turn to shoot bullets.
Oh, man, I'm getting to my.
Thank you so much, Mr. Mistry. Yes, Mr. Chaudhary.
My lords, before I show my lords some of the documents, Lord, in 5 minutes, if I may just factually summarize how the sequence of events unfolded. Because, my lord, what is before your lordship is after the second round of litigation or second round of arbitration. So there is a document of 2004 which is called a license agreement, which says it is valid for 6 years up to 2011. And why parties enter into a license? The document further records that though my clients are in possession and have been given possession by the Kolkata Port Trust, my clients at that point of time did not have a valid lease from Kolkata Port Trust. Therefore, the parties agreed they would enter into a license. And as and when my client would get a valid lease, further arrangements will be done.
On the same terms and conditions.
So, my lord, I'll place that recital. It is there.
Port is also watching behind you.
Yes, my lord, they are, my lord. They are watching, my lord. My lord, it has a long history, my lord. If I go, I'll take one day only to narrate the history.
Mr. Jena is there.
I know Mr. Jena was there earlier also. My lord, we had to go right up to Supreme Court to, my lord, get the money which they are collecting and, my lord, give it to the port. And the stand before the arbitral tribunal is, I am a direct tenant under the Kolkata Port Trust. That I'll come to that, my lord. That has not been told to your lordship.
No.
So, my lord, license, there is a document called a license agreement.
Right.
They pay license fees from 2004 up to 2010. License fees as per the agreement are paid. 2010, payment stops. The stand is taken that you have misrepresented to me that you are in valid possession, you don't have any title, right or interest in the property. Therefore, the agreement that you entered with me or this agreement is void. And my lord, they invoke the arbitration clause before the named arbitrator. The statement of claim is on record. I'll come to that. I'll just place 2 paragraphs from the statement of claim, where my lord, statement of claim, the stand is that the agreement is void and whatever rents or license fees I have paid pursuant to the agreement, that is to be returned. My lord, we file a counterclaim seeking eviction. We file a counterclaim seeking eviction. Lord, the erstwhile arbitrator is no more. I don't want to make submissions, my lord. There were allegations of section 12 regarding how he recorded minutes and all that. But to cut a long story short, Lord, they were successful in obtaining an award in their favor. Where, my lord, the arbitrator declared and this very agreement was relied by them in evidence, not by us. In evidence, arbitrator declares that the agreement is void. And an award is passed against my client, you return whatever money they have paid to you. And doesn't deal with the counterclaim at all. Because on the basis of a recording in an earlier minutes that as if I have abandoned it. For that matter, there was section 12 and all that discussions are there. I am not placing, well, the appellate court said section 12 may not be relevant. So, my lord, the award is passed in their favor. We as the petitioner in section 34 challenge that award. Lord, we are successful in getting the award set aside. Lord, award is set aside lock, stock and barrel. There is no partial setting aside of award. This is a point, my lord, and that has also been noted by the appellate court. Because, my lord, repeatedly, my lord, it has come up whenever it has suited their convenience. Partial setting of the award. Other points remain. Nothing remains of the award of the erstwhile arbitrator.
Yes. Completely.
Award set aside lock, stock and barrel. Now, my lord, against the setting aside of award, they prefer a section 37. And, my lord, since, my lord, they were in possession and had inducted third parties and were enjoying income from the property, there were section 9 applications and orders were passed, special officers and all that. From a section 9 order also, my lord, an appeal was preferred. Both these appeals were heard by the same division bench, presided by, my lord Justice Indira Banerjee at that point of time. Same division bench.
Just come back.
Yes.
Sir, may I be excused?
Yes, yes, absolutely. We stopped at Justice Indira Banerjee's decision bench.
Yes.
There are two Section 37 appeals, Section 9 and Section 30.
But by the time the Section 9 was heard, my lord, we were able to get hold of in the meantime, Port Trust had granted.
Section 9 was their Section 9.
My lord, both preferred an appeal. One, they had preferred an appeal. Again,
No, Section 9 was filed by whom?
Section 9 was our Section 9.
All right.
And my lord, in that, my lord, out of 5 prayers, 3 prayers were granted, 2 were not
Therefore,
granted.
both
To the
preferred.
extent, my lord, it was not granted, we had preferred and they had preferred.
Right.
My lord, the sum and substance, why I referred to it, because my lord, I'll place 4 paragraphs exactly from there.
Hmm.
My lord, the division bench, my lord, while setting aside the award,
Hmm.
my lord, because why the 34 was argued first, that time, my lord, the lease and the other details were, my lord, it was not placed in detail. My lord, the primary finding was that even if we assume whatever the learned arbitrator has said can be said to be correct, it does not permit the conscience of the court to find that the person will continue in possession whose possession is wrongful and without paying anything. So, my lord, shocked the conscience on that theory, the award was set aside. Then, my lord, the Section 9 was decided. And, my lord, the Section 9 appeal, my lord, records the entire fact and also the fact that in the meantime, subsequently, we had got a lease from Port Trust in our favor. And, my lord, most importantly, that records, and the same argument was advanced, that it's a partial setting aside and not that. Award having been set aside by the court, you cannot rely on any portion of it. That is the finding.
In the Section 9 appeals.
In the Section 9 appeal. The Section 9 appeal was a later judgment.
Then interpretation by the same court which passed.
Same court. Then, my lord, they go right up to Supreme Court, but because of the limitation in Section 34, my lord, unfortunate we couldn't, the SLP was dismissed and, my lord, in fact, my lord, I shall also show that the findings are that their possession has been illegal even by the Section 37 court in both the proceedings. But, my lord, 34 court and consequently the 37 court does not have the power to pass an award. That's a lacuna, my lord, in the 96 Act. The earlier, my lord, now I believe a larger bench is looking into it. In the 1940 Act, there was a power to modify the award or pass an award. But here, my lord, the line of judgment suggests that court's power is only setting aside thus far and no further.
We are hoping for a new interplay sort of thing.
That is.
It has to be there. Otherwise, it's impossible for the courts.
Because, my lord,
let alone advocates.
My lord, it has happened to me, my lord. We have got the portion set aside, again had to, well, just in this case, my lord, in fact, I'll show that after the division bench judgment, in fact, my lord, the Supreme Court bench had observed what remains after this.
Mr. Chaudhary, what we are doing is actually, we are saying that this portion is segregable from the other portion. We are setting aside this portion. So it's not a modification. Because we are setting aside one, leaving another. Because in this way, we are trying to segregate where no segregation is possible.
Language has been borrowed from the earlier act, which is the English statute of setting aside. But, my lord, they ignored the language of that earlier 1940 Act had a language of modifying the award. That has not been incorporated over here. That is, my lord, a big lacuna. So, my lord, I go back to the chronology. So, my lord, the agreement, then, my lord, they go before the arbitrator. Arbitrator passes an award in their favor. This very agreement is relied upon. The arbitration agreement is relied upon. That award is set aside. From that, my lord, division bench, that is set aside. The division bench affirms the setting aside but gives a completely different reason, saying that we do not agree with the observations of the learned trial court, but it shocks the conscience of the court that after we find that they are in complete illegal possession, they continue to remain in possession without paying anything. And once you are holding, and, my lord, the division bench courts, section 64 and 65, because it's an admitted possession, they come in possession qua the agreement. My lord, whatever name you call it, I shall show, they come in possession qua this agreement. They themselves say it is void, and this is a stand taken in both the proceedings. Before the erstwhile arbitrator, even before, my lord, the present arbitrator, they take the stand, it is void. So, my lord, the division bench says, if you yourself is saying that this agreement is void and you have come into possession by virtue of a void document, you are to immediately restore the possession. That is what, my lord, the law says, and that has been quoted 64 and 65. So, my lord, after the first round, after the award was set aside, by that time, my lord, the personnel named, my lord, had expired. So, my lord, we had to again file a section 11 because we could not mutually agree. In section 11, again, my lord, initially they agreed. And, my lord, this is, my lord, no fresh section 21 notice. We just wanted, my lord, our name to be agreed upon. We could not. Section 11, my lord, proceedings start again. Now, my lord, in this time, before the new arbitrator, my lord, we file our statement of claim. Self-same prayers asking for eviction. And they file their counter statement. Now no counter claim is filed.
Now, what is your explanation to previous counterclaim being abandoned?
My lord, that is, lordship will not find a single document from our part whereby even a letter we have said that we had abandoned. That was, my lord, there were allegations, my lord, the gentleman is no more under section 12. Fortunately or unfortunately, I am appearing throughout in the matter. I don't want to say, my lord, that anything more, my lord, departed soul. Lordship can understand that an award is passed saying that the agreement is void, and whatever I have got, I am to return it to them without there being, my lord, even let us assume I don't ask a counter claim. My lord, law says that you are to return the benefit. And in black and white, there is a counter statement and counter claim. And, my lord, because I sought his eviction, my lord, I filed a statement of claim. In the counter statement, even before this arbitrator, my lord, their stand is that the agreement is void, and void not because of insufficient stamping or non-registration, because of misrepresentation on my part.
That you are title. All right.
Even before the present arbitrator who passed the award. So, my lord, we took out an application of interim award of eviction. My lord, two stages, my lord, the arbitration was done with. Interim award of eviction, that your stand it is void. It is the same stand there. There is already the division bench finding over here that under 64 you are to return it. My lord, the learned arbitrator has passed it on that basis. And, my lord, even the other contentions, my lord, if you say it is lease, that has also been terminated. And you yourself treated it as a license and you said, I am only to remain in possession till 2011, that has also gone. So, whichever way you look at it, and based on your pleading, I don't require any trial because your best case is the agreement is void. It is an admitted possession, you were put in possession by virtue of the agreement. Therefore, eviction is a matter of course. This is, my lord, the award. Against this, my lord, all these elaborate submissions are being made. Now, my lord, I just show your lordship three documents. Kindly, my lord, first take the license agreement, which lordship will find at page 348, volume 2. Oh, achha. Lord, I am told that they had shown the license agreement from another page, but page 54 also it is there. Page 54.
Then we'll take that because if you have marked that.
Lord, page 54 of volume 1, lordship.
Thank you. With the same copy, then it will help us. Yes.
Lord, kindly come to page 58, which is the internal page 4 of the license agreement. But I'll refer to the internal page because
right,
I have marked it in my liquid text in a different.
Yes. এই শুনুন না, এটা এগুলো সব সরিয়ে নিন তারপরে। ও আচ্ছা, ওনার Yes.
The two recitals are very important. Kindly see my lord, internal page 4, recital H and I. Although in terms of the said order, my lord, this is the order of the division bench of Kolkata High Court, my lord, where my lord, we became the lessee in respect of that property of Kolkata Port Trust. Although in terms of the order of the licensor, that is my client, duly paid the entire area lease rent to Kolkata Port Trust, it has not yet renewed the lease of the said premises as directed by the order dated 1st December 2004. Even without the lease being formally renewed in terms of the order dated 1st December 2004, the licensor has been and continues to be in possession and occupation of the said premises. Malad, we came into occupation because this was a property of a company in liquidation which my client purchased and ultimately we were in possession. So my possession is admitted by them and I'll show that why this license was agreed. Licensor has been and continues to be in possession and occupation of the said premises, having been put in possession thereof by the official liquidator at the time of delivery of structure, plant and machinery lying at the said premises to the licensor. Then recital I is very important because it takes the wind out of the argument, that lease and otherwise. Both parties how it understood. In the absence of a formal renewal of lease, upon being approached by the licensee for the grant of a sublease of the said premises, the licensor has instead, kindly mark the word instead, agreed to grant a license in respect thereof for a fixed term of 6 years commencing from 1st August 2005 on terms and conditions contained herein, which have been in turn agreed upon by the licensee. Then, my lord, 6 years, lordship will find commencing from November 2005 till 31st October 2011. Then, my lord, kindly come to clause 4. Internal page 6. Page 50, it's running page 59. If in the meantime, the lease of the premises is formally renewed by Kolkata Port Trust in favor of the licensor, it will negotiate the grant of a sublease of the said premises to the licensee on the same terms and conditions of this agreement and will grant such sublease in its favor, whereupon the license granted hereby shall automatically come to an end. So because we did not have a lease in our favor, the arrangement was of the license, it's fixed period. In the meantime, we get a lease, license will come to an end and a formal lease would be done. This was the arrangement, both the parties are conscious. So no question of registration because neither of us are treating it as a lease. This being the agreement, now kindly see, the first statement of claim, which lordship will find at page 79, volume 1. But again, I'll be referring the internal pages because the statement of claim is there twice in this paper books. I have unfortunately. Kindly come to paragraph 9, which is at page 82, running page 82 of my lord's brief. Even before the order of Supreme Court was made, the respondent entered into, here in this statement of claim, F. on my client is the respondent and they are the claimant. Respondent entered into an agreement with the claimant on or about 26 December 2004, whereby the claimant was inducted into the premises mentioned at P10 Taratala for a term of 6 years, commencing from 1st November and expiring on 31st October 2011. It was agreed by and between the parties that the period might be extended for further period of 3 years on mutual agreement between parties, but at the sole discretion of the respondent. The said agreement dated 26 December, the claimant was inducted, whereby the claimant was inducted. Well, it kindly marks the expression. This is the pleading. The said agreement dated 26 December 2004, whereby the claimant was inducted, expressly provided respondent would bear and pay all rents and taxes payable past or in future in respect of the premises, including rent to the port authorities and taxes payable to Kolkata Municipal Corporation so and so. The claimant was not responsible. Lord, I skipped the next paragraph, not relevant. What is the license fee and all that? Kindly come to paragraph 11. I'm sorry. 11 or 12. I'm sorry, my lord, kindly come to paragraph 12. Paragraph 11 is again the license fee rates. Internal page 7. The claimant was put into exclusive possession and occupation of said premises at the time of execution of the said agreement. Recital that we are not executing a lease because you don't have a lease in your favor. We are getting into a license arrangement. Second, I have been put in possession by virtue of this. And my lord, I'll shortly show that they are saying that the very agreement which put me in possession is void. If that's so, we don't have to go into the issue of lease and license. Straight away under 64 and 65, according to you, it's void. Return the benefit that you have got. And that is exactly what the tribunal has, my lord, given. Since then, the claimant has been and still is in lawful exclusive possession and occupation of the premises, paying amounts to and so. My lord, now, my lord, there are other paragraphs also, but now kindly come to para 18. The claimant has been constrained to stop payment of rent after September 2010 when the petitioner came to know. Well, this petitioner is the claimant itself. I believe typographical error or find and replace gone wrong. When the petitioner came to know that the respondent had never had or has any right at all in the said premises. In fact, the representation made by the respondent at or upon execution of the said agreement are entirely false as would appear from below. And then, my lord, particulars are given. Then, my lord, kindly come to 20 and 21. The respondent, on the basis of deliberate misrepresentation made by it to the claimant as regards its status in respect of the said land, had induced the claimant to enter into the agreement. Detailed particulars have already been stated. Consent of the claimant to the agreement have been procured by misrepresentation. The said agreement of 26 December is wholly void and not binding upon the claimant. Claimant is entitled to seek a declaration that the purported agreement is null and void and the same be delivered up and cancelled. Pleading of section 31 of the Specific Relief Act. Straight away kindly come to the reliefs claimed.
No, but in the document you clearly mention that there is no lease, and that's why you are giving
Correct,
license. And when, as and when it is given, we'll consider negotiate sublease.
That is why, my lord, they had taken this point in the section 16 application before the my lord arbitrator. The second round of procedure.
Yes.
The learned arbitrator, my lord, that one paragraph was placed. Consequently, I agree with the submission of Mr. Chaudhuri, my lord. That paragraph I'll come. Where, my lord, the learned arbitrator has noted that the agreement is recording why this license was entered into. My lord, I'll come to that. But para 31 quickly, if I may show you, lord. Para 31.
Yes.
Claimant is entitled to continue to remain in possession and use and enjoy the same for its business in any event till 31st October 2011. And today, my lord, all these are, my lord, 12, 13 years have passed thereafter. 14 years have passed. Entitled to renewal. And if rent is not mutually, license fee is not mutually agreed, then arbitrator will determine it. Well, these are the contentions. Well, kindly see now the reliefs claim. para 38 at page 96. None of the claims are outside the purview of arbitration clause. Claimant claims an award as follows: delivery up and cancellation of the agreement, that the same be declared null and void. Award directing the respondent to pay a sum of 1 crore 88 lakhs and odd with compound interest at so and so. Pay a sum of 50 lakhs as may be determined by compensation. Then, my lord, relief 4. Award be made declaring that the termination of the agreement by the respondent is bad and illegal, and respondent has no right to interfere and disturb the possession and enjoyment of the claimant. My counterclaim, so far as this is concerned, is also on record, which is at page 98, volume 1. But kindly see paragraphs 4 and 5 of my counterclaim. And all this is before the first arbitrator. Notwithstanding the revocation of license and or termination of lease. My lord, we revoked the license because they were not paying. And we also wrote a letter, if you are contending it's a lease, then also this is 106 notice, treated as that. The claimant, however, continued and is still continuing to wrongfully and illegally possess, occupy and use the said premises. Claimant is continuing to do, although in the meantime the period of the license in any event expired on 31st October 2011. In the circumstances, the respondent has already filed an application before this tribunal for an interim award against the claimant under 31(6) of the Arbitration Act. The instant counter-statement and counterclaim is as such filed without prejudice to the claimant's rights and contentions in the said application. So, my lord, we had a 31(6) even before the erstwhile arbitrator. Saying that it is terminated, you say it's void, you give it. Now, my lord, then comes the award which was passed, page 211. Volume 1, my lord, the award is passed. Lord, I'll straight away come to the operative part
But
of
you
the
don't take a pleading regarding section 64 in the line of section 64, 65 here. That it is null and void, that's why. You say they have continued despite termination.
first time, yes, my lord. I must.
And in this, yes.
But now, in the second round, the award that we are faced with, specific pleading of 64 and 65 has come, because, my lord, by that time our argument before the division bench, my lord, is already recorded and the findings are there.
Yes.
I'll come to that.
Yes.
Lord, kindly see, my lord, we had given a written notes of argument. And, my lord, my written notes of argument says that I am claiming this. But kindly see in the award, page 13, internal page 13, 223, running page 223. Well, fourth line. From the notes of argument, however, it appears respondent had made a claim for possession of property because the claimant had stopped paying monthly license fee from 1st October 2010. I do not find any substance in this contention. The property belongs to Kolkata Port Trust. The respondent cannot earn any rent or license fee in respect of the property from the claimant, as the respondent had no right, title and interest over the property at any point of time. Therefore, there was no legal obligation on the part of the claimant to continue to pay the monthly license fee to the respondent. Since the respondent had no right over the property, it could not have earned any money from the claimant either in form of rent or license fee. The respondent had claimed that they had terminated the license to the claimant. In my view, the respondent, not having any right or interest over the property in question, cannot have any right to terminate. They are holding my hands and coming into the property, and then if I am being held, I don't have a right. Their position is worse. And my lord, one more finding I just wanted to show. My lord, kindly just go back to internal page 12 at page 222. Lord, around 6 lines from the top. Since the respondent had no right over the property, they cannot grant any license or tenancy of the property in favor of the claimant. The claimant is in physical possession of the property, but it has obtained such possession through Efkalon, but Efkalon had no legal right. Lord, after noting all this, my lord, the appellate court said that it is shocking that even if I assume that the arbitrator had this, so on this ground I am setting it aside. It shocks the conscience of the court. So, my lord, this was the purport of the award. Lordship will find, my lord, at internal page 14, my lord, whatever license fees I had collected, a money award was passed in their favor. And then, my lord, at page internal page 17, my lord, kindly see, this is the award. Agreement is declared null and void, delivered up and cancelled, and money award of 1,51,00,000. And after having this set aside, when I go for arbitration again, because the agreement is admitted, well, it was an admitted document. So evidence is all on the documents which are not admitted before the arbitrator. Because both parties have relied on it. Can they now turn around and say that this is a different proceeding? I'll come to 36 later, my lord, but Stamp Act is not required. I am going on the face of it, that it's a license. And both parties are treating it to be a license because of this reason. So, my lord, this is the award of the learned arbitrator. Then, my lord, the section 34 court, by the order of 6 December 2014, at page 228, my lord, kindly come to, my lord, internal page 5. My lord, the section 34 court, unfortunately, my lord, got into the question of bias, which the section 34 does not permit. So the appellate court, my lord, modified that. The finding was the same, the reasons were supplanted. I just want to show, my lord, internal page 5 of the order. So from the, that's the second para. So from the aforesaid discussion, it can be considered that if the arbitrator acted in a biased manner, which was...
It is not telling with our copy.
I'm sorry.
The respondent claimed, internal page 5, page 234.
Oh, I'm sorry, my lord. In fact, I am reading from page 461A. Anyway, my lord, I'll...
Internal page 5, we are at...
Well, kindly come to page 9. Well, that's the certified copy. This was a typed copy, so it was not matching. Page 236, internal page 9.
Yes, yes.
Now it will match. So from the aforesaid discussion, it can be considered that the learned arbitrator acted in a biased manner which was prejudicial to the rights of the parties. So in the ground that the award should be set aside under section 34 so and so of the Arbitration Act, an award can be challenged under 34 on the ground that it was against the terms of the respective contract and it was contrary to the fundamental policy of Indian law and contrary to the justice and morality. The agreement dated 26 December. Well, one thing Lordship would notice that the arbitrator had referred to the notes of the argument where we are seeking eviction and how he has dealt with it. An award can be challenged under 34 on the ground it was against terms of the respective contract and fundamental policy, contrary to fundamental policy of Indian law, contrary to justice and morality. Agreement dated 26 December itself recognized the right of the petitioner to grant a leave or license or tenancy of the property in favor of the respondent. But in the impugned award, the arbitrator has gone beyond the terms of the contract, holding that the petitioner had no right in the property and has no right to let out or to grant leave or license in respect of the same. It goes without saying that all such questions can be decided by the court of law. So it goes without saying that the aforesaid finding of the learned arbitrator is contrary to the substantive provisions of law. Furthermore, it appears that in the award, the learned arbitrator proceeded to allow the respondent to continue in possession of the property after termination and also after expiry of the period of agreement and without payment of any license fee or rent to the petitioner. Furthermore, the learned arbitrator directed the present petitioner of this case to refund the rent or license fee paid by the respondent with a finding that the petitioner had no right to enter into the said agreement with the respondent and consequently beyond the scope of consideration by the arbitrator. Furthermore, by the award, learned arbitrator created a perpetual right in respect of premises so and so in favor of the respondent. The authority of the arbitrator to decide any dispute between the parties came through the agreement between the parties dated 26 December. But interestingly, the impugned order, the learned arbitrator declared agreement null and void, which is beyond the scope of adjudication. Well, here, of course, arbitration agreement is separate. I am not on that. So, after this, so far as the aforesaid reason, impugned award cannot be sustained and it is allowed. Now, straight away kindly come to the appellate court order.
Nobody took the point of section 116 of the Evidence Act, Mr. Chaudhary.
116 is internal page 7, page 234.
Because that obviously stares one at the face. Can you challenge a juror relationship? And if it's created,
that has been noted by the arbitrator.
Anyway, yes. So we go on to the next volume.
So, kindly come to the division bench order.
Where is that?
Page 121.
All right. This is the section 37 from section 9.
From section 34. That is why, over here, Lordship will find that, the appellate court, it proceeds on the premise, the tenor of the judgment is that yes, it's a possible finding, but after holding that these can be possible findings, lastly, the conclusion is that it shocks the conscience of the court that even after all this finding, you don't return the possession. I'll come to that. This is the general principle 168. The factual finding of the learned arbitrator on the basis of materials then available.
Where is that?
I am sorry. Page 168, internal page 48. Second paragraph.
Yes.
But in fact, the appellate court goes into even to say the interpretation of the arbitrator of 116 of Evidence Act is also a plausible one because on the facts then available. And then, section 9, by that time, all the facts were before the court, Lordship will see the difference in language. I'll come to that. But I am proceeding chronologically. The factual finding of the learned arbitrator on the basis of materials then available, kindly marks the expression, the appellate court has consciously used it. Efcalon had no right to license out and the said premises is unexceptionable, not liable to interference. Then, 116 is discussed. Last line of that paragraph. Learned arbitrator's interpretation of 106 is a plausible one because, those line of cases were shown that whether it's a plausible one or not. Then, even after this, page 169, second paragraph. From the award, it is clear that possession of Efcalon was not disputed. It was also not disputed that the appellant had obtained possession from Efcalon. The learned arbitrator held that Efcalon had no right whatsoever of the property. Then, kindly come to after all this. Oh, 169, I must also place this third paragraph. Learned arbitrator found that the appellant not being a tenant of the premises and Efcalon not being landlord, first part of 116 would not be attracted. Furthermore, the appellant had not denied the right of Efcalon to possession of the said premises as purchaser of assets by the company in liquidation, armed with the order of court.
No, it also applies to licensors.
Now, kindly straight away now come to page 174.
Yes.
Well, when this section 34 or section 37 out of the 34 was being heard, well, the logic of the appellate court, even if I assume this to be correct, this to be correct, this to be correct, this to be correct, and then in last they say it is shocking, whatever may be the reasons, bias and all, we do not agree, set aside. Then, my lord, in the second round, when the section 9 comes, all the facts are now before the court. I'll show that. A distinct change in language. My lord, kindly come to 174. Second paragraph. We do not agree with most of the reasons recorded by the learned court below for setting aside of the award. However, it does not permit the conscience of this court to sustain an award which is in effect and substance allows the appellant who had no right whatsoever to the premises to remain in occupation of the premises without payment of occupation charges. If as rightly held by the learned arbitrator, if Calon had no right to license out the premises, the appellant who had been inducted into the premises had no right to be in occupation of the said premises. What remains after this? And they are trying to say, no, this is the partial setting aside of the award. And
So
all that.
occupation charges was not the pivot. The illegality of their possession was the pivot.
You are continuing in occupation.
Without occupation charges was a surplusage. I
Correct.
mean, that's also another factor.
In fact, my lord, the tenor was that even if I give benefit of doubt to the learned arbitrator, it's a plausible one. If your case is it is void and he was not entitled to give a license to you, you are not entitled to remain in possession. Then, my lord, it is a fundamental principle of law as enunciated in section 64 and 65 of the Contract Act that a party rescinding a voidable contract is obliged to restore the benefit derived from the contract. Even if a contract were ab initio void, all benefits received thereunder would have to be restored. The appellant was obliged to pay occupation charges for the period during which the appellant was in occupation, if not to Efkalon, at least to Kolkata Port Trust, the owner of the premises. That also, my lord, they could not show. In our view, the learned arbitrator committed a fundamental error of law in not directing the appellant to restore the status quo ante at the time appellant was put into possession. This partial award theory, my other thing has not been interfered with. This is categoric finding of the division bench. The award, in our view, patently illegal so far as the award allows the appellant. This is only a clarification. It is not that the rest of the award is remaining valid. In so far as the award allows appellant to remain in the premises, enjoy the premises and or carry business thereat without being saddled with any obligation whatsoever. The impugned award is unconscionable and thus against public interest. It is well settled an award which is unconscionable should be set aside. Now, this finding of unconscionable is based on twofold facts. Number one, that you on your own showing admitted that you have entered the premises through this license agreement and you are yourself saying that it is void, so return under 64. And the second part of the argument is that so long you are in occupation, you are bound to pay. So only one line is being, my lord, extracted and it is being said. Only this finding has been set aside, rest remains. My lord, that is why, my lord, I read these other paragraphs. Now, my lord, this is so far as section 37 from the 34 is concerned. My lord, in the meantime, in fact, my lord, both the judgments are of the same day, but my lord, chronologically, the argument was, my lord, I believe the order was made ready and my lord, it was both published later. So now Lordship will see a distinct difference in the language of the same appellate court. My lord, kindly now takes the section 37 from the section 9 order, page 899, volume 4. Let kindly.
Yes.
Well, at page 910. Internal page 10.
Yes.
Well, last paragraph will show this categoric finding that the award has been set aside lock, stock and barrel by a judgment and order dated 6
More
December.
importantly, the appeal was dismissed as a whole. The award had already been set aside lock,
Yes,
stock and
the
barrel.
learned 10th additional district judge set aside the award. Star Trek file an appeal being FMA 919 against the judgment and order of 6 December of the 10th additional district judge at Alipur setting aside the award. The said appeal has been dismissed by a judgment and order passed by this court earlier today. So no question of, my lord, partial setting aside. And this point has been further clarified, my lord. I just
If the
straight
appeal
away
is
show.
dismissed as a whole, and we also saw the award, there was no qualification. Sorry, 34. 34, there was no qualification.
Correct.
Simply sit set aside. And that the appeal against that is
This has also been clarified. I'll come to the kindly straight away come to page 926, internal page 26. I'll place one para on this point and again go back to the preceding paragraphs of the judgment.
Yes. Yes.
Well, second last paragraph. In any case, the award having been set aside and an appeal filed in this court from the judgment and order setting aside the award having been dismissed, Star Trek cannot claim the benefit of the award. Well, what was argued here was attempted to be argued then also, and this was totally rejected. So the partial award theory, my lord, is gone. And here also, my lord, kindly see page 925. I go back.
Yes.
Second paragraph. Star Trek had in effect claimed that Star Trek had exercised its right to repudiate the license agreement, which was voidable at the option of Star Trek, and even stopped paying license fee or occupation charges to Efcalon. It is doubtful whether a contract could have been avoided on the ground of misrepresentation if the veracity of the factual representation could have been ascertained with due diligence. Moreover, as observed above, it was the case of Star Trek that Star Trek had allegedly been threatened with eviction. Star Trek was not actually evicted. Star Trek was never dispossessed from the said premises. In any case, it is a fundamental principle of law as enunciated in 64 and 65 of the Contract Act. Party rescinding a voidable contract is obliged to restore the benefit derived from the contract. Even if a contract is ab initio void, all benefits received thereunder would have to be restored. There can be no dispute that even if it is assumed that Star Trek's agreement with Efcalon was voidable at the option of Star Trek was still obliged to restore all benefit which Star Trek derived from the license agreement. Having been inducted by Efcalon, Star Trek cannot and does not have any independent right to occupy the premises, far less any right to let out the said premises and earn occupation charges from the said premises. If it is assumed that the license agreement was void as contended by Star Trek in the arbitration proceeding, Star Trek would not be entitled to retain the benefits it derived from the license agreement. In other words, Star Trek would have to refund occupation charges earned by Star Trek by further subletting the premises to the occupant. Then, my lord, I read this.
But
Then, my lord,
one thing,
after-
Mr. Chaudhuri, sorry, section 37 is preferred, 1 against 9, 1 against 34. Section 9 is of a limited scope, not binding. So section 37 order from arising from 9 cannot supply the reasons for section 34.
No, I am not saying that. I am only.
But the same bench, you can obviously take advantage of
But
the same date.
I am only saying two things. I am not saying. I have shown that the reason.
So
of
the 37 against section 34 stands still date. In its own
37
right, in own right.
The reasoning of 64 and 65 is there in the 37.
Exactly, that
from
is there. Right.
That's a reiteration. The reason why I am showing this is to, my lord, deal with the argument that the other findings of the arbitrator remains. That, my lord, that attempt was made before the appellate court. They said we have set aside the we have upheld that order. We have upheld that order. The appeal has been dismissed.
So not as an independent finding in a section 37 against section 9, but as a by way of clarification of the section 30.
Correct. After clarifying, my lord, then, my lord, as in section 9, kindly see 926, prima facie it appears. That is why, my lord, the division bench is conscious because it's exercising jurisdiction now of section 9. Prima facie it appears Star Trek was not entitled to remain at the premises or utilize the premises or earn occupation charges or rent by subletting after termination of the license on ground of default, so and so. Even assuming the license agreement had been wrongly terminated, the license was for a period of 6 years, commencing from 1st November and expiring on October 2011, extendable by a further period of 3 years by mutual agreement. Star Trek has been in possession of the said premises over 10 years. The license expired on 31st October. The license agreement was not extended. Even if the license agreement were to be renewed, the license agreement would still have expired on 31st October. The license agreement having expired, Star Trek is obliged to restore possession of the premises to FCalon. We cannot but take judicial notice of the subsequent development of June 2015, when Kolkata Port Trust executed a deed of lease in favor of FCalon, whereby Kolkata Port Trust leased out the premises for 30 years till from August 2003. Well, this observation now comes in. This takes away the argument that the agreement was void because I did not have a formal lease from Kolkata Port.
That has been, we have noticed that also previously also.
So, my lord, there are twofold reasoning. Number one is 64-65, that your best case is the agreement is void. If this is the case, you come up with the arbitrator, before the arbitrator, under 64 and 65, restore the benefit. And second is, for prima facie case, license has been terminated. Even if you dispute the notice, it was till 2011. Or even better, you have further 3 years, that also has gone. So whichever way you look at it, you cannot remain in premises. But because, my lord, I read it as a lacuna of law, my lord, we had asked that, my lord, the division bench also said, can we are exercising jurisdiction under 34 in 37. Can we pass an award? Well, we had to say we can, you cannot. In fact, my lord, the bench of the Supreme Court, my lord, while dismissing their special leave petition, also said what remains. Eviction order should have been passed. If you proceed further, we'll invoke our powers under Article 142. And my lord, that was a 10-second affair, but that is a different thing. This is, of course, nothing is on record. I am just indicating it's a lacuna in law that, my lord, we have to further, my lord, fight for another 5-6 years because, my lord, a lacuna that a 34 court cannot modify the award. Well, at page 928. In view of the execution and registration of deed of lease dated 23rd June 2015 between Kolkata Port Trust and FCalon, whereby the said premises has been leased out to FCalon for a period of 30 years with retrospective effect from 4th August 2013, this court has no option but to proceed on the basis that FCalon was at all material times in lawful possession of the premises. In any case, Star Trek having been inducted by FCalon in terms of a license agreement, FCalon is estopped under 116 of the Evidence Act from questioning the right. So now, my lord, the finding is given by the division bench. What was said that, all right, even if I accept to be plausible, but this is...
It was expression not plausible even, subject to what they say.
No, my lord, I believe the tenor of writing the judgment was that, all right, let us assume this is also plausible. Let us assume this is also plausible. Let us assume this is also plausible. But then if you are saying the agreement is void, why will you not restore the benefit? And why will you not pay for the period you are in occupation? So it does not permit, it shocks the conscience of the court, and it was there. And section 9, my lord, when this was done, my lord, this lease had come in and we had placed it. My lord, this also was done. But even after this fact, my lord, we are still waiting for more than 6 years, my lord, to get them finally evicted. My lord, last paragraph of this judgment at page 929. My lord, in fact, my learned leader had pointed out, second last paragraph, as argued by Mr. Mukherjee in proceedings under section 9, this court cannot embark upon adjudication of issues which do not pertain to the arbitration agreement between the parties. Then, my lord, the para before that, be that as it may, this appeal being a continuation of proceedings under section 9, it is not for this court to go into the deviousness of epsilon in obtaining orders of court. My lord, then they argued that, my lord, my clients had misled the court to obtain the orders. And my lord, they are still in occupation. My lord, last paragraph. As observed above, there is now a lease of the premises in favor of epsilon. License agreement has prima facie been terminated. Even assuming there was no termination, the license agreement between epsilon and Star Trek has expired by efflux of time. Epsilon is not only obliged to vacate the said premises, but is also liable to pay arrears of license fees or mean profit for the period during which Star Trek remains in occupation. In our view, the learned court below rightly appointed a special officer or receiver. My lord, rest of the findings I am not going into it. Only, my lord, one finding at page. Yes, my lord, page 933, second last paragraph. This is the observation of the appellate court. It is rather interesting that Star Trek should contend that the Star Trek has lawfully been inducted into the premises by epsilon and thus entitled to protect its possession after getting the license agreement adjudged void in arbitration by contending that the same had been induced by misrepresentation.
That adjudication was set aside.
So, my lord, this is what the order was. Then, my lord, a second set of pleadings comes. We invoke the arbitration. I am not placing in detail, my lord, that. My lord, yes, my lord, there is a letter, my lord, we asked for, because by that time, my lord, the erstwhile arbitrator had expired. So, my lord, we ask only, this is not a fresh section 21. Because, my lord, if we give a fresh section 21, limitation and everything will come in. My lord, it is only that you agree to a personnel. My lord, they don't agree. My lord, we go
In any event, section 11 having been allowed, they cannot take that point.
Section 11 allowed, we then, my lord, they file, because, my lord,
They participated in the arbitration.
They were not interested in filing any claim any further. So, my lord, we proceeded, my lord, we filed a statement of claim and we filed a section 31(6) application for interim award. My lord, I just show one paragraph from that. Kindly have a look at page 327.
Again,
volume 2. And, my lord, this second round of arbitration we had to undertake because, my lord, we were unable to get the possession. The money award was set aside. We were unable to get possession and we were unable to get, my lord, mean profit or any charges after September 2010.
This is because of the limitations of section 34 power.
Limitation of section 34.
Interestingly, Mr. Chaudhary, section 37 and section 9, the scope of the court is broader than, that is much broader actually. There are
in fact, my lord, we had
can grant more reliefs.
We had, my lord, unfortunately,
your powers are coextensive with section 9, therefore you can grant more reliefs.
My lord, unfortunately, my lord, order 41, rule 33, which we have in civil procedure code,
not there.
That is not there in 37.
Main problem. Main
so,
problem.
my lord, and my lord,
we should have a order 41 rule 22 and order 41 rule 33.
Yes, and my lord,
that would suffice.
That being the position, my lord, even the division bench or appellate courts, my lord, they say no, we are at best exercising jurisdiction under 9 or under 34. We can't have a power more than that.
No, but section 9 is
Yes.
much more than.
Yes, yes. My lord, in fact, my learned junior rightly points out, before I show, my lord, the pleading in the 31, my lord, kindly see the statement of claim which we filed before the second arbitrator, 257, page 257, one paragraph. My lord, what fell from the bench just now, my lord, whether this 64, 65 Contract Act pleading and all that, my lord, everything has been taken.
257.
257 at page 270.
257 is something else. Right.
I'm sorry, my lord, 257
No,
is
it's
the
all-
forwarding letter,
So
250.
270, we are at 270, yes.
Let kindly come to page 269.
Yes.
It should be paragraph 30.
Hmm.
The claimant states and contents in terms of clause 16 of the agreement, the respondent, my lord, here now I have become the claimant.
Hmm.
In the second round, the respondent was obliged to delivery of vacant and peaceful possession of the said premises. In fact, my lord, the second set of pleadings came in because the original records from the erstwhile tribunal could not be traced out. He had expired by then.
Oh.
And my lord, parties were not agreeing to that is gone. So we had to file fresh. The claimant states and contents in terms of clause 16 of the agreement, respondent was obliged to deliver up vacant and peaceful possessions to the claimant in the event of the claimant terminating the license in terms thereof. Not only has the respondent failed and neglected to do so, notwithstanding the termination of the agreement, but has also continued to occupy the same even after expiry of the period of the same. In any event, in view of the contention of the respondent that the said agreement dated 26 December 2004 is null and void, and the respondent being put in possession as per terms thereof, the respondent by its own admission does not have any sort of right, title and interest in the premises. So this is the pleading, my lord. And then, my lord, in the statement of claim, then, my lord, para 31. In the event it is contended that respondent was a tenant or a lessee, such purported tenancy or purported lease from month to month has also been duly determined. Without prejudice to the aforesaid, and in any event, in view of the case made out by the respondent that the agreement dated 26 December is null and void, assuming but not admitting such contention to be correct, the respondent in any event having received an advantage under the agreement dated 26 December is bound to restore to the claimant the possession of the said premises inasmuch as the respondent had received such possession under the agreement from the
Mr. Chaudhary, there is one issue which is troubling us. That issue is that once they take a point of nullity, that's nullified. I mean, that's set aside. Then it's decided by a competent forum that nullity point goes. I mean, after that, can you resile on that resile and then say because you relied on nullity, but which has been turned down by the court?
No, my lord, this is proceeding. My lord, the award was passed.
Issue stable, will it be available to you?
Award was passed on the basis of, because my lord, even before this arbitrator, their best case is, my lord, it's a nullity. Even
Here also they have taken a point of
yes, counter statement. Now I come to the counter statement.
Oh, acha, acha.
At page 290, kindly come.
Oh, they stick to that point.
Yes, yes.
Then
My lord, my lord, I can understand their position also, my lord. They are enjoying, my lord, every month they are earning 30 lakhs and above 30 lakhs from the property.
equity we can understand, Mr. Chaudhary, but even then,
Yes, my lord, point of law, I am.
even if they say that nullity, null and void, that point is now barred by res judicata because it has been decided by the topmost court in this hierarchy that it's not a nullity. The agreement is not null and void.
No, my
After
lord,
that, 64,
res judicata, it is also res judicata that if you say it's if you say it is void, then under 64, 65, you are bound to. This finding is also staring. And notwithstanding the finding, even before the arbitrator, they say the same thing. The arbitrator has quoted, my lord, from the division bench judgment.
Court finally decides that it's not a null and void document. After that, whatever the party, even if the party repeats the same thing again in a different suit, then can that be taken? Can that be a basis of granting a decree?
The arbitrator has proceeded on threefold premise. My lord, before this second round also.
This one, yes.
My lord, they file a section 16. Section 16 is registered and non-registered. Again, lease comes back.
That's a different aspect.
I'll show the section 16.
We'll consider that.
There is a specific finding. It is not a lease, it's a license. So that goes. Then, my lord, because section 16 also the challenge is, my lord, it has to be, my lord, it merges with the award. It is an award of eviction.
That's not binding. Not binding.
Yes, but my lord, it's a section 34 point. I am not saying it's binding. It's a section 34 point. The arbitrator rejects the section 16. Then, my lord, deals with our application under 31.5, which
proceeds on threefold premise.
proceeds on threefold premise. If you say it's a license, then my lord, it is a specific finding. It is not a lease, it's a license. So that goes. Then, my lord, because section 16 also the challenge is, my lord, it has to be, my lord, it merges with the award. It is an award of eviction. Yes, but my lord, it's a section 34 point. I am not saying it's binding. It's a section 34 point. The arbitrator rejects the section 16. Then, my lord, deals with our application under 31.5, which proceeds on threefold premise. the period has expired or it has been terminated, whichever way you look at it. If you say the agreement itself is void, on principles of 64 and 65, you are bound to restore possession. And in the section 11, already their lease theory has been debunked. My lord, 106 notice was also there as abundant caution. Assuming you can treat it as a lease. But my lord, that is why I showed your lordship recitals H and I, that why no lease was done. Because we did not have any lease in our favor. What sublease will we give?
There are three grounds on which the award could have been passed. 64, 65, expiry of the lease license, whatever. And if it's a license, filing of the claim is itself termination. You need not even give a notice.
Revocation at will.
That was superfluous.
Correct.
So the first ground, we have some issue regarding 64, 65, whether that could be a basis because it has been decided, adjudicated finally that
Yes,
it's not
my
a
lord,
nullity.
it is, my lord, it will not be an issue.
But regarding the other two issues, we are
My lord,
apparently at
I-
one with you.
my lord, I
License
want
could
to-
be
I
yes.
want to dispel any cloud from my lord.
No, license could be terminated and expiry of that document.
I want to dispel.
First one cloud is there.
Yes, I want to dispel the cloud only
that.
on the simple point, my lord. I reached thus far but couldn't get the fruits of the litigation for lacuna in law. All I am doing is I am relying on that judgment and I am coming and asking it. It's like a preliminary decree and a final decree. Because my lord,
it was not a decree. It was a finding. The decree, ultimately the decree which you are relying on.
Which was passed by the arbitrator, relying on the finding. My lord, could the arbitrator have come to a different finding in teeth of 64 and 65? In view of the pleading, my lord, I'll show 31.5. My lord, lordship is the adjudicating authority.
Mr. Chaudhary, I am making my point clear. In the previous round, the last phase of that, it was held that if you yourself claim it's a nullity, you should have vacated. In the same breath, what is being set aside is that it's a nullity. So the conclusion of that, the decree, if you say so, the decree is that it's not a nullity.
No.
The preceding finding is if you say it's a nullity, you should leave.
What is being set aside is the award, which says it is.
I'm saying decree intentionality. Award is the decree here. So the award.
So let us assume.
Yes.
Let us assume.
Yes.
After the setting aside.
Lock, stock, barrel set aside, as you said.
Yes. After the setting aside, there is an agreement.
It's not a nullity.
It's not a nullity.
No.
So in the second round, they come up and say, no, it is not a nullity, but it is something else.
That is precisely what we are saying. 64, 65 is based on nullity.
Well, I am coming to that. So in the second round, they can come and say, no, the agreement is valid, but I have this defense. Second round, the first defense is it's a nullity.
If they take the defense, even then, Mr. Chaudhary, the defense is not a valid defense in view of a res judicata.
Exactly. And that is why
that defense could not be a basis of award.
That is why on threefold grounds, my lord, the award of eviction has been passed.
The rest of the two folds we are agreeing, prima facie. But the first fold we are not, because if 64, 65 is the basis, then you have to say that the deed is a nullity.
My lord, it is under 31.5, my lord, the principles are akin to judgment upon admission.
64, 65 is not that if you claim it's a nullity. Mr. Chaudhary, 64, 65 is that if you rescind, when an agreement is discovered to be void, yes.
The award proceeds on the premise that why should I go to a trial? Even if I assume your best contention, my lord, kindly see 814. One paragraph, my lord, I am sorry. Just
814.
Para 56.
Para 6, yes.
Para 56. 814.
56, yes.
On a similar consideration.
What is this? What is this a part of?
Award. I am showing from the award.
This award.
Yes,
Current
award.
Yes.
Apropos, my lord's query.
Yes.
Even on a similar consideration, even assuming that the case of the respondent is accepted to the effect that agreement itself is null and void, even then the same cannot be so treated, especially in view of the observation of division bench so and so. In any event, it is now clear upon reading and understanding the judgment of Honorable Division Bench, if the claimant had no right to license the property, similarly, so on. This is even on the assumption. That is, I do not require any trial to give this order of eviction, because even if I assume your best defense, what will you say in trial? That I have misrepresented, therefore the agreement is void? Even if I assume such a case, this is on the assumption, not whether this is being a decree. Well, I'll come and satisfy. Well, only thing, well, Monday and Tuesday, I am in some difficulty. Well, kindly, well,
Wednesday then.
deeply obliged.
Heard in part, the matter be placed in the list for further hearing on March 19th of March 19, 2025. এগুলোতে ঢুকে যাবে। এসব ঢুকিয়ে দেবো।